it seems like Hillary Clinton is going to have to answer additional questions. Judicial Watch is a rabidly right-wing group, but they have been fanatics for going after Hillary Clinton. And in this case, they use the Freedom of Information Act in order to push questions on Clinton. Clinton refused to answer some of these questions, but the judge has essentially slapped down her refusal and is forcing her or compelling her to answer certain questions. Now, these questions pertain to ClintonEmail.com, which essentially had, let's say, state secrets on those on our own devices. They want to know, how did you start ClintonEmail.com? Who came to the conclusion that they needed to start ClintonEmail.com? And beyond who came to conclusion for it, who told you that the emails weren't there, that 90 to 95% of the emails were available to the people who needed them in the State Department? They're trying to make the point that she was lying, and they want to spell it out in explicit detail that she was lying. Take a look at this, and I'll keep this one quick because the story is relatively small. Judicial Watch announced today that the U.S. District Court Judge Emmett G. Sullivan ruled that within 30 days, Hillary Clinton must answer some additional questions under oath to additional questions about her controversial email system. In 2016, Clinton was required to submit under oath written statements, answers to Judicial Watch's questions. Clinton objected and refused to answer questions about the creation of the email system, her decision to use the system despite warnings from the State Department's cybersecurity officials, and the basis for the claims that the State Department had 90 to 95% of the emails. Now, after a lengthy hearing yesterday, Judge Sullivan ruled that Clinton must address two questions. Question 1. Describe the creation of ClintonEmail.com system, including who decided to create the system, the data was of the decision to create the system, why it was created, who set it up, when it became operational. Because from their standpoint, why did you do this? And not why did you do this? Look, we've argued that she did this because she wanted to hide information. Because the only reason you would do this seems like such an elaborate ploy, was that the state wouldn't have information available as you're using your email system. You're hiding it from freedom of information. If you do stuff for the state government or for the government, it's work product. It's work product. It is for us to interrogate. At the very least, it's supposed to be there for public records. Now, Clinton putting this thing in her basement completely ignores this process and bypasses this process. And you have to ask, why are you going through this elaborate step in order to prevent this information from being available to the public? What are you hiding? What are you hiding? Number 2, during your October 22nd, 2015 appearance before the U.S. House of Representatives Select Committee on Benghazi, you testified that 90 to 95% of your emails were in the state's system. And if they wanted to see them, they would certainly have been able to do so. Identify the basis for the statement, including all the facts on which you were relying to make this statement. How and when you became aware of these facts, and if you were made aware of these facts by or through another person, identify the person who made you aware of these facts. And again, you can see where they're going. We think you were lying. We think you were being dishonest. We believe that you knew that it wasn't 99 to 95%. But giving you the benefit of the doubt, explain yourself. Who told you this? Where did you get these facts from? Were these of your own creation and your own consciousness? And if so, from where? What source? Did you read it in a coloring book? Did the guy on the street tell you? When you were at your bodega looking at your email, did the guy whisper something to you saying that you have 95% of your, well, whatever? Where did you get this number from? Their point is you were lying. But they want her to try to come up with a reason I guess you could say that them asking her this question in this way is trying to nail that point home, that we believe you were lying. If not you, who was magnificently incompetent to say such a thing? Judge Sullivan read his opinion from the bench, deciding that the question about the creation of the email system was within the scope of discovery. Judge Sullivan rejected Clinton's assertion of attorney-client privilege on the question about the emails in the state's system. The court refused Judicial Watch's media requests. They had other requests, but the judge refused those. The key point here is that Hillary Clinton is going to have to answer additional questions. Speaking of this, I've showed this clip before about the Comey thing, but I'm not going to show this one again. Look, Clinton skated on the email thing. If there was anybody else, she would have been caught. There's a man sitting in jail now named Brian Nishimura. Brian Nishimura essentially effectively did the same thing as Hillary Clinton did, with the unenviable bonus of his last name not being Clinton. I don't like this outfit per se. It's not that I agree with Judicial Watch as a whole, but I do agree with him on this particular point. The Freedom of Information Act, that's trying to get at the root cause of, you had all of these emails that weren't on your system. And just to put a fine point on this, the guy who Trump put up there now as an interim attorney general, now that Jeff Sessions has been handed his walking papers, wrote a post, an article for USA Today, saying he would have went after Clinton. I would indict Hillary Clinton. Because Comey made this point that no reasonable prosecutor, he's like, I'm a reasonable prosecutor. That woman flagrantly broke the law. Right here. Yet, Director Comey's judgment was that no reasonable prosecutor will bring the case. I disagree. I believe myself to be a reasonable prosecutor, and when the facts and evidence show a criminal violation has been committed, these individuals involved should not dictate whether the case is prosecuted. One statute that the Secretary Clinton should be charged with violating is 18 U.S.C. Section 793F. Under this section, a prosecutor must prove that the person had lawful possession of information relating to national defense. Through gross negligence, the person permits the information to be removed from its proper place of custody, or given to someone else, or lost or stolen. Although it might be intuitive that the Secretary of State's lawful possession of information that relates to national defense, the facts laid out by Director Comey also establishes that is exactly the type of information in the case. Of the emails turned over or recovered by the FBI, 110 contain information that was classified at the time it was sent or received, of which 8 email chains contain information that was top secret at the time it was sent. The facts also show that it was gross negligence when she removed the information from the State Department security. Secretary Clinton made the decision to use personal email system, one that had inferior security to the State Department's or even another commercial vendor's email system, meaning she would have been better off using Google. It would have had more security than the one she ended up using. A reasonable prosecutor may ask if on numerous occasions an unknown State Department employee had top secret information from a secured system, emailed that information to a Gmail account, and stored the information on a personal server for years, would that individual be prosecuted? I think yes. Take a look at this. Trey Gowdy is interrogating Comey and essentially making a very basic point. If a person lied this many times to you, dealing this particular case, is that not some evidence of guilt or malfeasance?
Private email, was that true? Our investigation found that there was
Mr. Gowdy for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true?
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old...
Basically, his point is, if a person is lying to you about all of this stuff, isn't that not some kind of consciousness of guilt in this particular process? The woman had state secrets, many of which were top secret. And if there was anybody else, and not just that, a Secretary of State and the former wife of a president, meaning she was very conscious and cognizant, or had to be, of the nature of top secret information and the need to keep that information under lock and key. Gross negligence. Straightforward. And straightforward is too strong, but I'm making the point that the idea that no reasonable prosecutor would push for this case is utter nonsense and folly. Comey decided not to prosecute. Comey was being pressured by Loretta Lynch in this case. Comey himself said that he was disturbed, and I'm paraphrasing, by the language that she wanted him to take on when he was talking about the case, because it sounded like she wanted me to talk about the case as if with the same language as Clinton was talking about it during the campaign trail. Loretta Lynch was leaning on him. She was pressuring him. When Bill Clinton ends up with a conversation between Loretta Lynch, it is nonsense to believe that the only thing they were talking about their grandkids. Comey comes in, clears Clinton, had written up the documents to clear her before even talking to her, lied about that. Lied about it. I mean, come on. I guess I'm making a point. They got Clinton off and then put Trump on. And this is not coming from somebody who's a supporter of Donald Trump. I can't stand him. By the same token, this was utter nonsense. And the pretending that this case was legit, no, not so much. I may not be necessarily on the side of Judicial Watch, but what they're doing here in this case, yes, I do approve. Hillary Clinton should answer those questions. And if we're being honest, Hillary Clinton, if she was any other person, would have been indicted. Call it what it is. Call it what it is. I'll leave it here. I can show Comey's testimony where Comey lays it out in painstaking details. There are other people who would have got their hands on the information, most likely. There are all of these classified top secret emails that ended up on the computer. Hillary Clinton's device was unlocked. It was unsecure, even to the standard of Gmail. Like, he lays out all of her sins. She was using an unprotected device even when she was traveling. But gross negligence, no, we haven't hit that standard. We didn't hit that standard. It's nonsense. Anybody else would have been indicted. Just saying. Judicial Watch is still going after Hillary Clinton. These guys are rabid in regards to going after Clinton. But on this very particular point, I agree. I concur. And I want to hear those answers myself. So I'll leave it here. I did this video again because the other video got away from me. It got a little bit long. But this video, I tried to stick to topic. Thanks all. If you enjoy the content, please feel free to share, like, subscribe. Please hit the notification bell so you can make sure you can see my live videos. And if you really enjoy, you can support the work through PayPal or Patreon. Thanks all.